Vote is carried. Proceed, Attorney General.
Thank you very much.
Members, please, the comments at times reaches the ear of the chair. So please be careful, please be careful. So again, the member who said that, please get up and retract and apologize.
I retract.
And again, member for St. Augustine, I just said it. It reaches the air, please. And it goes for members on both sides. No, please, members. I recognize the Attorney General. You have your statement.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I have been authorized by the Cabinet to make the following statement. This statement is with respect to the matter of Civil Action 2022-04567, Brent Thomas and Specialist Shooters Training Center Limited against the Attorney General and the Director of Public Prosecutions, and the judgment delivered by Mr. Justice Davindra Rampersad on the 25th of April, 2023. Mr. Speaker, may I say at the outset that I am constrained to be limited in what I say this afternoon in this statement at this time, for the reasons which will be made clear as I proceed. I nevertheless make this statement because I recognize and acknowledge the legitimate concerns which arise out of that matter, exacerbated by the judgment delivered on the 25th of April, 2023. Let me add immediately that nothing that I say here in this statement falls outside of our permitted hierarchical judicial structure, tiered, T-I-E-R-E-D, to include within the hierarchy of our Supreme Court that judges at first instance may make errors.
Mr. Deputy Speaker, I rise on Standing Order 48-2 on the matter of this being sub judice. The government announced that this particular matter of Brent Thomas against the Attorney General is on appeal.
Honourable AG, can you shed some light on the... One second.
Mr. Speaker, protect me from the leader of government
Again,
business and the Prime Minister.
don't worry, I will.
Mr. Deputy Speaker.
On what standing order? On what standing order?
Members,
Prime Minister asking a...
members, please. All right. I'm going to recognize the Prime Minister, and then I'm going to recognize you after Mr.
I'm standing on a point of clarification, Mr. Speaker. Am I correct to interpret that what we heard here is the same Brent Thomas in the question section as against the Brent Thomas that is coming here? Could the minister clarify for us? Is the same Brent Thomas that took up the question time? Is that the same Brent Thomas is we talking about now?
Yes. Member for Naprima, you have a concern?
Is it an appeal, and therefore is it sub judice?
Right, one second. Okay, members, again, the Attorney General has a statement to make, right? The Attorney General has just started his discourse, and I'm going to give him his opportunity in order to make a statement, keeping in line with the ruling of the sub judice rule, which I'm sure you are clearly aware of. So you can proceed. What information can be forthcoming, you will determine. Proceed.
Thank you very much, Mr. Deputy Speaker. As I was saying, let me add immediately that nothing that I say here in this statement falls outside of our permitted hierarchical judicial structure, tiered to include within the hierarchy of our Supreme Court that judges at first instance may make errors in the discharge of their judicial function, and the Court of Appeal exists to correct those errors. Firstly, Mr. Deputy Speaker, permit me to say at the outset that this matter raises considerations of national security, which necessarily circumscribes the detail which I can permit myself to outline today. Secondly, this matter concerns police operational systems and processes in which the executive has no role, which police operational systems the executive is constitutionally required to and does respect. We know that the Commissioner of Police has ordered an investigation. That investigation must be allowed to take its course, and we all look forward to its outcome. In this regard, it is important to reiterate and to emphasize that which has already been said by the Honourable Prime Minister of this country, Dr. Keith Christopher Rowley, that the executive has played no role in the events and the facts given rise to the judgment and commented on by the judge. As Attorney General, however, I am able to speak to this matter, as I do here today, by reason of my constitutional office of Attorney General. As Attorney General, I am one of the named defendants in this matter, as prescribed by the Constitution, answerable for and in the promotion of the constitutional protection of the rights of our citizens, due process, and the protection of the law. To that extent, Mr. Deputy Speaker, my knowledge of what I speak to today is informed by A, the instructions given by the police to the legal team of attorneys representing the Office of Attorney General as a defendant in the matter, and B, in certain limited respects, other matters which have since come into the public domain and to which I also speak. Mr. Deputy Speaker, it bears emphasis that, recognizing that the matters to which the judgment speaks are of a police operational nature, the Trinidad and Tobago...
I rise on 49 sub judice. I think the Attorney General is going in a realm I don't think it...
Again, members, the Attorney General knows the road that he is going down. He has a statement to proceed with.
Deputy Speaker, wait, just at the beginning, I rise on 48.8 also. At the beginning of the Attorney General's speech, he brought the Justice Budu Singh in disrepute.
Overruled. Overruled. Proceed.
Thank you, Mr. Deputy Speaker. As I was saying, the Trinidad and Tobago Police Service, under the leadership of its Commissioner, must be allowed its full operational remit within the law to pursue its investigations and necessarily to bring its investigations and any resulting charges to conclusion in accordance with due process. Thirdly, Mr. Deputy Speaker, as you will appreciate, my office has filed an appeal against the judgment given in this matter and will today be filing an application before the Court of Appeal to hear this appeal urgently in priority over all other appeals.
Standing Order 49. The Honourable Attorney General has said that he has put the case on appeal. And if it is an appeal, he cannot talk about the substantive merits of the case.
Overruled.
Thank you, Mr. Deputy Speaker. For the record, Mr. Deputy Speaker, I will not speak to the details of the appeal which has been filed, except to say that so urgent is the need for a definitive, final appellate adjudication in this matter that I have already given instructions to London solicitors to retain English counsel from the outset so that that counsel may become immediately and fully apprised of this matter, working with our team of local attorneys so as to become fully up to speed, ensuring that howsoever this appeal is determined by the Court of Appeal, we are ready immediately to protect the state of Trinidad and Tobago by urgent access to our final Court of Appeal, the Judicial Committee of the Privy Council. Suffice it to say, Mr. Deputy Speaker, that I have done this because, as I said at the beginning, we accept that judges, at first instance, can make errors. In this case, I will say only that...
I did stand on 48.8. Judges, we cannot comment on the conduct of any person, including a judge. And he's saying that the judge could make an error. It is clear. It is clear.
Overruled.
Thank you, Mr. Deputy Speaker. Fourthly, Mr. Deputy Speaker, I immediately make the point that there is an aspect of this matter which, on my advice and in my judgment,
Mr. Deputy
has
Speaker,
not
I rise
been
on order
appealed.
49.1. The Honourable Attorney General is creating a real risk of prejudicing the merits of this matter. He is going down, Mr. Deputy Speaker, he is going down a road of challenging aspects of the first instance judge. That is what he's doing. He's abusing ministerial statements.
Overruled. Proceed.
Thank you, Mr. Deputy Speaker. Let me repeat what I just said, which was interrupted, so that the member may hear what I'm saying before he objects. Fourthly, I immediately make the point that there is an aspect of this matter which, on advice and in my judgment, has not been appealed, and which was conceded by lead counsel representing the Attorney General in this matter, to which I immediately turn. Mr. Speaker, in his judgment, the judge found that Mr. Thomas...
Deputy Speaker, it is
Mr. Deputy
unacceptable
Speaker, I
now,
rise on
49.
49.1, standing order 49.1. Are we allowing the Attorney General to abuse this ministerial statement? Abuse the Parliament.
All right. Thank you, member. Proceed.
Thank you very much, Mr. Deputy Speaker. In his judgment, the judge found that Mr. Thomas was, quote-unquote, abducted in Barbados by the Trinidad and Tobago Police Service and
Mr. Deputy
returned
Speaker,
unlawfully
order
to Trinidad and
49.1.
Tobago.
We are speaking to the merits of the judgment. The Attorney General cannot dissect what is convenient for him.
Proceed.
Mr. Deputy Speaker, in this regard, it is important that this House be apprised of indisputable facts which form part of the record of this matter and which, consistent with law, demonstrate the errors. 1. The state of Trinidad and Tobago...
Mr. Deputy Speaker, this is becoming outrageous now. Outrageous. The Attorney General continues to traverse the merits of this case.
Thank you. Again, members, the chair has already approved the statement. The Attorney General shall proceed.
Mr. Deputy Speaker,
Deputy Speaker,
as I was saying...
Deputy Speaker, 48.8. I want you to look at 48.8, please, on due respect.
Again, overruled. Proceed.
I was saying, thank you, Mr. Deputy Speaker. 1, the state of Trinidad and Tobago conceded before the judge that the return of Mr. Thomas from Barbados to Trinidad and Tobago was unlawful, having been effected outside of the extradition process provided for by the extradition, open brackets,
Mr. Deputy
Commonwealth
Speaker,
and
order
Foreign Territories Act.
49.1. We are going into the merits of the first instance judgment. And they have said the Attorney General has lodged an appeal. He has also said that they have applied for an expedited hearing of the appeal. All of this goes to the merits of the matter.
Okay, honourable member, you can say it as loud as you care to. Overruled. Proceed.
Mr. Deputy Speaker, I was in the process when the members stood to object. I was in the process of referring to the Extradition, Commonwealth and Foreign Territories Act, Chapter 1204 of the laws of Trinidad and Tobago.
Mr. Deputy Speaker, with all due respect, I would
What's standing order?
like
What's
to
standing
hear,
order, please? What's standing order?
Mr. Deputy
Member is
Speaker,
rising on, please.
Mr. Deputy
Can you indicate
Speaker,
what standing order the member
on
is
the
rising on,
standing
please?
order which
What standing order?
requires
What standing order, please,
that I
please.
hear
What standing
what
order
is
is
being said.
Mr. Standing order? I stand on standing order. I stand on standing order 48.2.
Thank you.
Standing order 48.2.
I heard you, Honourable Prime Minister.
I would like to hear the Attorney General in silence, please.
Okay. So again, members, the statement is being presented by the Attorney General. the Speaker's chair has given the approval for the Attorney General to make the statement. Again, let's listen to the Attorney General as we know to maintain the decorum of this House. Proceed.
Thank you very much, Mr. Deputy
Member for
Speaker.
Couva North. I have not recognized you, member for Couva North. Please, please. Proceed.
Thank you, Mr. Deputy Speaker. In light
Chair,
of the
I rise on
interruptions,
Standing Order 48-8. This is a rape of the standing orders of this House. This is an abuse of the Parliament.
Again, member, I'm sure you can use a better word than that. And honourable members, yes, we know we have the standing order, which what each member is free to stand up and present. But I have already ruled. No, it's not a discourse, member. I have already ruled, members. Proceed.
thank you, Mr. Deputy Speaker. I will repeat what I was saying, which has been interrupted. 1. The state of Trinidad and Tobago conceded before the judge that the return of Mr. Thomas from Barbados to Trinidad and Tobago was unlawful, having been effected outside of the extradition process provided for by the Extradition, Commonwealth and Foreign Territories Act, Chapter 12, Number 4 of the laws of Trinidad and Tobago. See, in this regard, paragraph 223 of the judgment in which that concession
Mr.
is
Deputy
recorded.
Speaker, again, I rise on Standing Order 48-2 and 49. The Attorney General is quoting paragraphs of the first instance judgment that is under appeal, Mr. Deputy Chair.
Proceed.
Thank you, Mr. Deputy Speaker. The Central Authority Unit of the Office of the Attorney General and Ministry of Legal Affairs of Trinidad and Tobago, responsible for extradition matters, was not consulted for advice. That aspect of the matter, as conceded, is not being appealed by the Attorney General. 2. On more than one occasion...
Mr. Deputy Speaker, I rise on Order 49 again, 49(1)(c). The Attorney General cannot say with certainty that what he is doing here will not create a real and substantial danger of prejudice to the fair determination of the appeal.
Proceed. Proceed.
Thank you, Mr. Deputy Speaker. 2, with reference to the use of the word abducted, which the Minister, the Attorney General of Barbados, has spoken to in the Parliament in that country, there can be no criminal offense of abduction involving criminal intent unless such criminal intent was shown beyond reasonable doubt to have been present in the minds of the officers of the Trinidad and Tobago Police Service. The evidence was to the contrary. In that regard, permit me now to refer to the undisputed evidence of the Director of Public Prosecutions, who swore an affidavit on oath in the proceedings before the judge on the 6th of January 2023.
Mr. Deputy Speaker, the Attorney General is arguing the appeal.
Members. Silence. Proceed.
Thank you, Mr. Deputy Speaker. Paragraph 15 of the affidavit of the Director of Public Prosecutions, I quote, "In this matter, I can confirm that officers from the..."
I rise on Standing Order 53(1)(f).
And E.
And E.
Right. Again, members, let's listen in silence, which the standing orders ask for. Proceed.
Mr. Deputy Speaker, reference to paragraph 15.
Chairman, Mr. Deputy Speaker, I rise on Standing Order 48-2. If we are upholding the standing order, we should uphold all the standing order. And the Attorney General cannot continue to trespass on the standing order like this.
Paragraph 15, thank you, Mr. Deputy Speaker, of the affidavit of the 6th of January of the Director of Public Prosecutions. Quote, "In this matter, I can confirm that officers from the Trinidad and Tobago Police Service have sought legal advice from the Office of the Director of Public Prosecutions on 2nd October 2022 and 4th October 2022. Further, Assistant Superintendent, I delete the name, has at paragraph 77 of his affidavit disclosed that advice was sought from the office of the DPP concerning charges and Mr. Thomas's returning to Trinidad and Tobago on the 5th of October 2022. Paragraph 16 of the DPP's affidavit, quote, officers of the Professional Standards Bureau of the Trinidad and Tobago TTPS sought legal advice in relation to some of the contemplated charges and arrest warrants. On both occasions, I, says the Director of Public Prosecutions, Mr. Gaspard, I was out of the jurisdiction. As a result, Mr. George Busby, in his capacity as then Acting Director of Public Prosecutions, met with the officers of the Trinidad and Tobago Police Service. Paragraph 17 of the affidavit of Mr. Gaspard, Director of Public Prosecutions, quote,
Mr. Deputy Speaker, it is clear that the Attorney General...
And in order 49, the AG is quoting from the actual documents that are in the court. This matter is sub judice, is under appeal. The AG should know better.
And again, honorable members, according to Standing Order 24, statement by ministers, 24.4, a question will be permitted at the end of the AG statement in order for you to be elucidated on the matters. Proceed.
Thank you, Mr. Deputy Speaker.
Asking a question after you're breaching the standing orders is not in order. It's not in order.
Proceed.
Thank you, Mr. Deputy Speaker. Paragraph 17 continues the Director of Public Prosecutions. Further, after each meeting, Mr. Busby contacted me, relaying in summary the information which was presented to him and informing me of the advice which he intended to give. Paragraph 18. Further, I quote, in relation to the issue of charges, Mr. Busby informed me, and I verily believe that he was unable to render an opinion on the basis that he did not have sufficient information.
I rise again on Standing Order 49. This is the Red House, not the Hall of Justice. Let the AG go on and argue the appeal in the courts, not here.
Overruled.
Thank you, Mr. Deputy Speaker. I verily believe, informed by Mr. Busby, and I verily believe that he was unable to render an opinion on the basis that he did not have sufficient information presented to him in the meeting on 2nd October 2022 to so do. It is important to note the fact that Mr. Busby did not have sufficient information from his conversation with the officers to advise on charges. That does not mean that there was not sufficient cause and or evidence to support charges. It was within the discretion of the TTPS, who had all, and the word all is in bold italics and underlined, and that is the emphasis of the Director of Public Prosecutions in his affidavit. It was
Mr. Deputy
the
Speaker,
discretion.
Order 49.1. Mr. Deputy Speaker, very simply, what the Attorney General is doing here is leading fresh evidence into the Order 49.1.
Thank you. All right. Thank you, member. Overruled. Proceed.
Thank you very much, Mr. Deputy Speaker.
48.8. The Honourable Attorney General is stating, making a case that it was not an abduction. The judge said it was an abduction. And therefore, the conduct of the President, any person performing the function of President, member of the Senate, House, or judges of the Supreme Court, or persons performing judicial function, shall not be raised except upon a substantive motion moved for that purpose.
Overruled.
Thank you, Mr. Deputy Speaker. It was within the discretion of the Trinidad and Tobago Police Service, says the Director of Public Prosecutions at paragraph 18 of his affidavit, that the TTPS, who had all the information and who had conduct of the investigation, to decide that they had sufficient information and evidence within their possession to charge. Paragraph 19. Further, it should be noted that once myself or anyone acting on the main authority in all DPP gives legal advice, it is solely at the discretion of the Trinidad and Tobago Police Service as to whether they will act on that advice, and if so, the manner in which they will do so. Paragraph 20 of the
Mr.
affidavit.
Deputy Speaker, again I rise on Standing Order 49. Please protect the public's interest and the sanctity of this Parliament from this dangerous abuse by this Attorney General.
Proceed, Attorney General.
Thank you, Mr. Deputy Speaker. Paragraph 20. Mr. Busby was able to advise on the issue of the arrest warrants. Mr. Busby informed me, and I verily believe, that the advice given in respect of the arrest warrants did not touch on the issue of how those arrest warrants ought to be effected or executed. Further, I am informed by Mr. Busby and verily believe that his advice in this regard was for the Trinidad and Tobago Police Service to communicate the existence of those arrest warrants to the Barbados authorities so as to have Mr. Thomas arrested. No advice was given as to how the arrest was to be done in Barbados or how, if arrested, Mr. Thomas was to be returned to this jurisdiction, unquote. I will reread that last paragraph, Mr. Deputy Speaker, having regard to the interruptions. Paragraph 20, the Director of Public Prosecutions on the 6th of January 2023 put an affidavit in the court which was before the judge. Mr. Busby was able to advise on the issue of the arrest warrants. Mr. Busby informed me, and I verily believe that the advice given in respect of the arrest warrants did not touch on the issue of how those arrest warrants ought to be effected or executed. Further, I am informed by Mr. Busby and verily believe that his advice in this regard was for the Trinidad and Tobago Police Service to communicate the existence of those arrest warrants to the Barbados authorities so as to have Mr. Thomas arrested. No advice was given as to how the arrest was to be done in Barbados or how, if arrested, Mr. Thomas was to be returned to this jurisdiction. Mr. Deputy Speaker, at this stage, I say no more on this. No doubt, this affidavit of the Director of Public Prosecutions will be considered by the Commissioner of Police as she concludes her investigations into the actions of members of the Trinidad and Tobago Police Service. Mr. Deputy Speaker, subject only to that outstanding report of our Commissioner of Police, I entirely accept and endorse the remarks of the Honourable Attorney General of Barbados, Mr. Dale Marshall, King's Counsel, in the ministerial statement which he made yesterday to the Parliament of Barbados. I offer to the government and the Royal Barbados Police Force my apologies for the slur which has been cast on the actions of the Royal Barbados Police Service, who, consistent with the law and their oaths of office, were assisting the Trinidad and Tobago Police Service to the best of their ability in the investigation of alleged crimes in seeking to bring an alleged fugitive to justice. In this regard, Mr. Deputy Speaker, the statement of the Honourable Attorney General of Barbados delivered yesterday on undisputed facts is instructive as to the role of our regional agencies. With your leave, Mr. Deputy Speaker, permit me to quote from and to adopt the statement in that regard of the Honourable Attorney General of Barbados. Quote, I have earlier mentioned that there was involvement in the operation by two regional bodies which have both submitted reports. Their reports reveal that on October 5, 2022, the Regional Security System, RSS, headquartered in Barbados, received a request from the CARICOM Implementing Agency for Crime and Security, IMPACS, to transport 4 Trinidadian police officers from Trinidad to Barbados that evening. The aircraft departed Trinidad at 3:21 p.m. on October 5th and arrived in Barbados at 4:11 p.m. A further request was made to transport the same 4 police officers and a Trinidadian national back to Trinidad that same evening. The RSS aircraft departed the Grantley Adams International Airport at 5:08 p.m. and arrived at Piarco International Airport at 6:01 p.m., where the police officers and the Trinidadian national disembarked the aircraft and it returned to Bridgetown. That Trinidadian national was Mr. Brent Thomas. The coordination of the travel to Barbados of the Trinidad and Tobago Police Service and their return with Mr. Thomas was coordinated fully by CARICOM Impacts. Barbados has an Extradition Act, Chapter 189 of the laws of Barbados, which applies to a large number of criminal offenses, including the firearm and other offenses, for which the warrants of arrest for Mr. Thomas were issued. I can confirm that no request was made for the extradition of Mr. Thomas. The Trinidad and Tobago High Court has characterized, says the Honourable Attorney General of Barbados, has characterized what transpired in Barbados on October 5th last year in relation to Mr. Thomas as an abduction. That is unfortunate language. From the reports that I have received, I am satisfied that the actions of the Barbados Police Service have fallen short of applicable legal norms, such as acting under an extradition request. I, however, cannot associate myself with the description of the actions of the Barbados police officers as an abduction or, as has been elsewhere described, as a kidnapping. Close quotation marks. Mr. Speaker, permit me to say a few final things. Not only do I endorse the remarks of the Honourable Attorney General of Barbados in this regard, I go on record to acknowledge that before this matter emerged, I have been having discussions with the Honourable Attorney General of Barbados, Dale Marshall, King's Counsel, on important issues of our criminal justice system since we sat together at the recently concluded Regional Symposium in Port of Spain, which was hosted through the vision and efforts of the Honourable Prime Minister, Dr. Keith Rowley. One of the matters under discussion since then and ongoing is the implementation of the CARICOM Arrest Warrant Treaty. Unrelated to this matter and following on the next steps from that symposium, I have already twice met with heads of department of the Attorney General's office in Trinidad and Tobago and commissioned urgent legal work necessary to have Trinidad and Tobago ratify that CARICOM Arrest Warrant Treaty, consistent with the intention as espoused by Attorney General Marshall of Barbados that all of CARICOM needs to bring this treaty into full operation. Indeed, Mr. Speaker, following on that symposium, I have already exchanged a draft agenda with my CARICOM Attorney General colleagues for discussion following that symposium. Mr. Deputy Speaker, the work of the CARICOM Implementation Agency for Crime and Security, referred to as CARICOM Impacts, an agency for which Trinidad and Tobago provides financial subscription, and the Regional Security System, RSS, is equally of great import as part of our regional facilities to enable and facilitate support for each other. All of our CARICOM members, Trinidad and Tobago included, who have access to these CARICOM facilities, avail themselves of their services for myriad purposes. It would be very wrong not to acknowledge that work and the support which those agencies bring to our efforts. This country is engaged in a very serious battle to get the upper hand on crime to which all of CARICOM is committed. We in Trinidad and Tobago, Mr. Deputy Speaker, and within our CARICOM family, recognize that the task is one which calls for mature reflection, a commitment to purpose, and an embrace of rational discussion and collaboration within the framework of all applicable laws, recognizing the support which the executive must necessarily give to law enforcement agencies and efforts within the region. If it turns out that on the advice which they received from the Deputy Director of Public Prosecutions, that members of the Trinidad and Tobago Police Service misunderstood that advice and or misstepped, that will be for the Commissioner of Police to determine according to law, and the law will take its course. Trinidad and Tobago will attend to any and all of its consequential liability, such as may legitimately arise. But what should be made abundantly clear, Mr. Deputy Speaker, is that all available lawful measures must be employed to continue with unhindered law enforcement action against the criminal element, and these measures must proceed without let or hindrance and without hesitation. In this matter, the Trinidad and Tobago Police Service will continue to be supported even as the state acknowledges and respects the rights of all citizens. I say no more at this stage. Thank you, Mr. Deputy Speaker.
I recognize